Most Americans believe they have a right to privacy. Many Americans also want governments to protect them from bad actors. So what happens when our right to privacy collides with our desire for government to protect us? A recent Supreme Court case out of California involves the question of how far government can go to protect us. Specifically, is it necessary for governments to collect data about citizens in order to find criminals? As William Pitt the Younger said, necessity is the plea for every infringement of human freedom. While this case deals with California law, we should be asking a bigger question. Does government interest trump our rights, the Constitution of our states, and of the United States? So we'll discuss that next on the Constitution Study.
One thing you have to know wherever you make your stand came from a long through line of everyday Americans.
Hello there, everyday Americans, and welcome to the Constitution Study. This is where we read and study the Constitution. We teach the rising generation to be free. I'm glad you could join me today. As always, I'm going to ask you to share this video with others. Share the article, share the podcast. You can find all this information at constitutionstudy.com. It is all there, free for you to use and free for you to share. Later this month, I'm going to be announcing a new class I'm bringing out that you can join absolutely free and even get some discounts on some other classes while you're at it. So again, check out constitutionstudy.com. I'll discuss it a bit more at the end of the program, but right now, let's talk about government interest versus your rights. If you run a charitable organization and you wish to solicit donations, well, there are plenty of tax regulations with which you must comply. If your organization is in California, there's an extra regulation, one that was challenged by the Americans for Prosperity Foundation and the Thomas More Law Center. From the suit, the Attorney General requires that charities renewing their registration to file copies of their Internal Revenue Service Form 990, a form on which tax-exempt organizations provide information about their mission, leadership, and finances. Schedule B to Form 990, the document that gives rise to the present dispute, requires the organization to disclose the names and addresses of their major donors. Since 2001, these two charities have submitted the required documentation, though they redacted the donors' information to protect their anonymity. In 2010, California increased their enforcement of the law requiring these disclosures, California Code of Regulations Title 11, Section 301. And the Attorney General threatened them and other charities with suspension of their registration as a tax-exempt organization. Now, both Americans for Prosperity Foundation and the Thomas More Law Center sued in district court, alleging that the disclosure of their Schedule Bs violated their First Amendment rights and the rights of their donors. In both cases, the district court granted a preliminary injunction prohibiting the Attorney General from collecting the plaintiff's Schedule B information. The circuit court then vacated the injunctions and remanded those cases back to the district court. The district court held trials in both cases where they found for the charities. The Ninth Circuit again vacated the district court's injunction, this time remanding the cases back to the district court in favor of the Attorney General. The cases were eventually merged and were heard by the Supreme Court, which is why the case only carries the name Americans for Prosperity Foundation. Now, the Supreme Court reversed the judgment of the Ninth Circuit, but it's worth looking at their reasoning. The Chief Justice delivered the opinion of the court with respect to all but Part 2B1, concluding that California's disclosure requirement is facially invalid because it burdens donors' First Amendment rights and is not narrowly tailored to an important government interest. The court found that the California law violated the First Amendment rights of the donors. Specifically, the court reviews a petitioner's First Amendment challenge to California's compelled disclosure requirement with the understanding that compelled disclosure of affiliation with groups engaged in advocacy may constitute as effective a restraint on freedom of association as other forms of governmental action. While disclosing personal information does have a negative effect on freedom of association, as I've said so many times before, this cannot be a First Amendment issue since Congress did not make this law. The First Amendment reads, "Congress shall make no law abridging the right of the people to peaceably assemble." Now, it is, however, a violation of Article 1, Section 3 of the California Constitution, which reads, "The people have the right to instruct their representatives, petition government for a redress of grievances, and assemble freely to consult for the common good. Now, what the court did focus on is what level of scrutiny the court should use in reviewing this case. NAACP versus Alabama did not phrase in precise terms the standard of review that applies to First Amendment challenges to compel disclosure. In Buckley versus Vallejo, the court articulated an exacting scrutiny standard which requires a substantial relation between the disclosure requirement and sufficiently important governmental interests. Now, what is this standard of review and exacting scrutiny the court is talking about? Well, basically, it's a question of how hard the government has to work to infringe on your rights. See, according to the Free Legal Dictionary, in law, the standard of review is the amount of deference given to one court or some other applicable tribunal in reviewing a decision of a lower court or tribunal. The standard of review for questions of constitutionality fall under three levels. Rational basis. Generally, the Supreme Court judges legislation based on whether it has a reasonable relationship to the legitimate state interest. Intermediate scrutiny. Under the Equal Protection Clause, when the law targets a quasi-suspect classification, such as gender, the courts apply intermediate scrutiny, which requires the law to be substantially related to an important government interest. And finally, strict scrutiny, if a statute impinges on a fundamental right, such as those listed in the Bill of Rights or the due process rights of the 14th Amendment, then the court will apply strict scrutiny. This means the statute must be narrowly tailored to address a compelling state interest. Notice what all three of these standards of review have in common. They all place a government or state interest above the Constitution and your rights. In the 1976 Supreme Court case Buckley versus Vallejo, the court added a new term called exacting scrutiny, which requires a substantial relation between the disclosure requirements and a sufficiently important governmental interest. Now, what does this mean for the law in question? Well, remember the First Amendment. Congress shall make no law abridging the right of the people to peaceably assemble. The Constitution states that Congress shall make no law abridging your right to peaceably assemble, but the Supreme Court claims that's only true if there isn't a sufficiently important governmental issue. Put another way, they have said government has the authority to infringe on a right protected by the supreme law of the land. They just have to show that it's important. Now, while lawyers and the courts focus on the question of whether or not California's interest in finding fraud warranted infringing on rights of the charitable organizations and their donors, nobody seemed to pay attention to the actual violation of the Constitution of the United States. The court does not doubt the importance of California's interest in preventing charitable fraud and self-dealing, but the enormous amount of sensitive information collected through Schedule Bs does not form an integral part of California's fraud detection efforts. Now, I don't doubt the importance of California's interest in preventing fraud. Unlike the Supreme Court, however, I recognize that the people have a right to be secure against unreasonable searches. As the Fourth Amendment states, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Is it reasonable for the government to search your records without probable cause? Doesn't the idea of searching someone's papers and effects for potential wrongdoing drift dangerously close to a writ of assistance, which is defined as a writ of assistance, especially in colonial America, authorized a law officer to search in unspecified locations for unspecified illegal goods. In effect, California is issuing a writ of assistance, allowing their law enforcement officers to search the records of charitable organizations for some unspecified illegal activity. California is not only interested in the possibility of illegal activity at the charities that operate within their state, but also want to know who are their large donors. That means California is effectively claiming the need to search at least some of the records of those donors without any probable cause that they've done anything wrong. Doesn't anyone else see a problem with this? Now, usually, the dissent in these opinions provides some very interesting insight, not only into the dissenting justices, but the way the court views the Constitution and their role in the Republic. Although this court is protective of First Amendment rights, it typically requires that plaintiffs demonstrate an actual First Amendment burden before demanding that a law be narrowly tailored to the government's interest. Never mind striking the law down in its entirety. Not so today. Now, I would question how protective the court is of the First Amendment. So as I've already shown, it seems more interested in protecting the interests of government than the right to the citizens. Now, this is borne out later in the dissent. In so holding, the court discards its decades-long requirement that to establish a cognizable burden on their associational rights, plaintiffs must plead and prove that disclosure will likely expose them to objective harms, such as threats, harassments, or reprisal. It also departs from the traditional nuanced approach to First Amendment challenges, whereby the degree of means and tailoring required is commensurate to the actual burdens on the associational rights. Finally, it recklessly holds a state regulation facially invalid despite petitioners' failure to show that a substantial portion of those affected would prefer anonymity, much less that they are objectively burdened by the loss of it. According to Justice Sotomayor, who wrote the dissent, in order for the court to protect your rights, you must first show that you may suffer a harm other than the loss of your rights. Justice Sotomayor also notes that the court has traditionally treated infringement on the rights protected by the Constitution as something to be nibbled away at based on how much damage they see. Worst of all, according to Justice Sotomayor, it's the responsibility of the people to prove a burden other than the infringement of their rights, rather than that the state having the burden to show that they should be allowed to violate the Constitution. While we should be happy that the Supreme Court did reverse the judgment of the Ninth Circuit Court, there are plenty of issues with this opinion. Not the least of these problems is the continuing position of the court that your rights are less important than the interests of government. This case, though, should also open an interesting discussion. We are left to conclude that the Attorney General's disclosure requirement imposes a widespread burden on donors' associational rights. And this burden cannot be justified on the ground that the regime is narrowly tailored to investigating charitable wrongdoing, or that the state's interest in administrative convenience is sufficiently important. We therefore hold that the upfront collection of Schedule Bs is facially unconstitutional, because it fails exacting scrutiny in a substantial number of its applications, judged in relation to its plainly legitimate sweep. See, if the upfront collection of Schedule Bs is facially unconstitutional for the state of California, why is it not also for the United States? The answer appears to be less about the Constitution and more about federal supremacy. For one thing, each governmental demand for disclosure brings with it an additional risk of chill. Since the federal government is already collecting Schedule Bs, which might have a chilling effect on donors, the court doesn't appear to want another government entity collecting that data. This is where the viewpoint of the court comes into play. If the upfront collection of this data violates the rights of both the donors and the charity to be secure from unreasonable searches, then it's unlawful for a state or the United States to do so either. However, if it merely has a chilling effect on the donors, well, then all the court wants to do is limit that effect. This case is just another example of why we need to read and study the Constitution for ourselves, because those who are supposed to be upholding it are not doing so. Until we the people understand the limits we have placed on governments and require them to abide by those limits, then those governments are not exercising just powers. The Declaration of Independence states that governments receive their just powers from the consent of the governed. Instead, the people today are exercising powers at the consent of government. You know, there's an old saying that the devil's in the details. That's why details matter. It's why words matter. It's why I take the time to go through these opinions and not just cover the surface, but what is actually said. See, here we have a case where a lot of people cheered. Yes, it is wrong for the state of California to collect donor information from charitable organizations. But it's still, according to the court, okay for the federal government to do it. They're still collecting Schedule Bs at the IRS. We have this whole thing about First Amendment and associational rights, but the court completely ignores the unreasonable search protection. This is why I say we need to learn the Constitution for ourselves, because the people we have hired to support the Constitution, uphold the Constitution, abide by the Constitution aren't. And the people who are supposed to be holding them accountable aren't doing their job either. So it has to start with us. We need to read and study the Constitution. We need to teach the rising generation to be free. That's what we do here. So I have a couple things that you might be interested in. See, I've told you before, you should read and study, and I still have that challenge out there. read the Constitution. In the next few days, read the Constitution. Make 2 lists while you're reading it. One is something new that you found. One is a list of questions. Then come to the Constitution study, ask those questions. Either go to the Ask a Question page on the menu and post your question there, or join our live Q&A the second and fourth Thursday of the month. Ask your question there, and we will answer it. That's what we do. So check that out. And if you want to keep in touch, well, sign up for the newsletter. Because every month I send a newsletter with news about the Constitution study. So check it out, constitutionstudy.com. You can see the newsletter in the right-hand column. Just sign up for that, and you'll be in the know. I also want to point you to a couple other things. One is Constitution Scholars. Head to constitutionscholars.com, find out more. It's free to sign up. You do have to register, but it's absolutely free. You get access to books, videos, classes, and a community of other constitutionally minded people, other people that are students of the Constitution. So check that out as well. I also would encourage you to check out americaoutloud.com. I have a radio program 5 days a week, 4 p.m. Eastern Time on America Out Loud. And if you can't listen live, well, the podcasts usually hit the website a couple days after that. Again, you can find out more. Just go to americaoutloud.com. Under shows, just look for the Constitution study. You'll find my show page. There's all that information. All of this is there to help you become a better student of the Constitution, to know your rights, to defend your rights, to assert your rights, and to do so properly. And if there's one thing we need today, we need to stop depending on government to protect our rights. We need to learn to protect them for ourselves. Until we can hire people that will actually defend our rights in our state, local, and eventually federal government, we need to defend them ourselves. So I hope you found this interesting. I hope you're encouraged to learn more and defend your own rights. I hope you'll be back here next time for the Constitution study.
You have to know wherever you make your stand came from